We'll be starting with DPSP. So we are done with fundamental rights. DPSP article 36 to 51. Okay, so it's a part 4 of our constitution. 36 to 51 and 51A they have added a fundamental duties. Okay, DPSP का सिग्निफिकेंस क्या है एग्जाम रिलेटेड में थोड़ा फैक्चुअल है. Okay, so you have to remember the article names here और आर्टिकल नंबर. 39A क्या है, 44B क्या है, क्वेश्चन पहले से आ रखा है प्रीलिम्स में. प्लस यू हैव टू कनेक्ट इट विथ फंडामेंटल राइट्स फॉर मेंस पर्पस. ठीक है, यू हैव टू ऑल्सो कनेक्ट जैसे कि आर्टिकल 44 है यूनिफॉर्म सिविल कोड. यूनिफॉर्म सिविल कोड भी एक टॉपिक है, करंट अफेयर्स में है, तो ये भी मेंस पर्सपेक्टिव से आ सकता है. आपको सपोर्ट में लिखना है, नेगेटिव लिखना है और एक बैलेंस्ड आंसर चाहिए. फाइन. ओके, so we'll start article wise, one by one we'll be covering. So first of all, the article is 36, that is the definition of DPSP. Like in this part, unless and otherwise required, the state has the same meaning as in part 3. Part 3 is nothing but fundamental rights. So fundamental rights mein the definition of state has been given in article 12, okay, which you have already covered. So the definition is the same here. Okay, the definition is the same, so no need to, so they did not think of mentioning it again, so it is the same. Now coming to article 37. Article 37, it is the application of the principles contained in this part. Okay, so यहाँ पे the provisions contained in this part shall not be enforceable by any court. ठीक है, provisions contained in this part, that is in part 4, DPSP section, will not be enforceable, but the principles therein laid down are nevertheless fundamental in the governance of the country. When you give test series, आप बहुत सारे टेस्ट सीरीज दिए हो, एक क्वेश्चन आता है लगभग हर टेस्ट सीरीज में है कि which of the following are fundamental in the governance of the country. It is a DPSP which are fundamental. Fundamental rights are not fundamental in the governance of the country, because it is clearly mentioned in the constitution that the DPSPs are fundamental in the governance of the country, and it shall be the duty of the state to apply these principles in making laws. So it is the duty of the state, that is the government, to apply all these principles in part 4 in making laws. When they make laws, they have to apply these principles. Okay, so this is mentioned in article 37. Okay, so here the same thing has been explained here. The DPSP are not enforceable by any court, therefore the government cannot be compelled to implement them. They cannot be compelled. Okay, nevertheless they are fundamental in the governance of the country, and it shall be duty of the state to apply these principles in the making laws. So this statement and this statement can confuse you. So government cannot be compelled, उसको compel नहीं कर सकते government को कि आप implement कीजिए. For example, UCC article 44, but there are no laws as of now, so you cannot compel the government to implement this provision or any other provision of DPSP. But because they are fundamental in the governance of the country, so it is the duty of the state to apply these principles in making laws whenever they feel the time is right, whenever they feel. It's not like you have to do it, but it is the duty to apply these principles. Okay, now distinction between fundamental rights and DPSP. They constitute limitation. Fundamental rights are nothing but limitation upon the state action, but DPSPs are instrument of instruction. to apply these principles in laws. So it will work as instrument of instruction to the government. Fundamental rights are already implemented by the constitution. Okay, fundamental rights are already implemented or enforceable by the constitution, article 32. DPSPs are directives. These directives are required to be implemented by the state. The state can do only by or only through the laws. Okay. Fundamental rights are enforceable by courts. Already we have discussed article 32. All the petitions, writ petition, all those things we have already discussed. The directives are not enforceable by the courts unless and until there is a law. Okay. So this is article 37. Now coming to article 38. Article 38, the state shall secure a social order for the promotion of welfare of the people. Okay. So welfare of the people के लिए, so in a way it is nothing but socialism. So for the welfare of the people, you have to secure a social order. Here, clause 1, the state shall strive to promote the welfare of the people by securing and protecting as effectively as it may a social order in which justice, social, economic and political justice shall remain all the institutions of the national life. So it means कि they are promoting the social, the state or the government should promote social justice, economic justice and political justice. Okay, so see the name, see the word here: social justice, economic justice and political justice mentioned in article 38 clause 1. It was added later. Okay, it was added later, that is in the 44th Constitutional Amendment Act. 44th Constitutional Amendment Act, this clause was added. Okay. Clause 2. The state shall, in particular, strive to minimize the inequalities in income and endeavor to eliminate inequalities in status, facilities, and opportunities, not only among individuals but also among groups of people residing in different areas or engaged in different vocations. So it means it is promoting equality to minimize inequalities in what? See the word here, income inequality. It talks about income inequality because inequalities in income, this is the word, and endeavor to eliminate inequalities in status, inequalities in facilities and inequalities in opportunity. These are the words you have to remember. They can frame any kind of question in prelims to make it more difficult, because what happens is you do not read word by word. Okay, but UPSC has a there is a trend. UPSC asks from, मतलब आपको line by line within the sentences पढ़ना पड़ता है. Okay, not only among individuals but among groups of people residing in different areas or engaged in different vocations. So income inequality को कम करने के लिए this clause number 2 is there. And status में inequality eliminate करेंगे. Now see, there is also another catch here. This is minimize income inequality, minimize, but status inequality, inequalities in facilities, inequalities in opportunities. ठीक है, this and this, इसमें क्या होता है? इसमें eliminate, not minimize, totally eliminate. There is a difference between minimize and eliminate. This is the way you have to read. Whenever you read anything, for in particular for competitive exams, state and UPC, you have to read. This is the way how to read. Okay, which 99% do not do. That is why exam में they get surprised looking at the question कि हमको कैसे पता नहीं चला. आपको इसीलिए पता नहीं चला बिकॉज आप ऐसे पढ़ते नहीं हो. फाइन, ऐसे करोगे तो जो ट्रिकी क्वेश्चन आता है ना, क्वेश्चन आर नॉट डिफिकल्ट, क्वेश्चन आर ऑलवेज ट्रिकी. ओके, पॉलिटी कभी डिफिकल्ट आ ही नहीं सकता, बिकॉज पॉलिटी इज अ वेरी फिक्स्ड सब्जेक्ट, बट इट इज वेरी ट्रिकी. ओके. मतलब आप अभी भी बच्चों को पूछ सकते हो जो कि 3-3 साल से 4-7 साल से पढ़ रहे हैं पॉलिटी, 10 बार पढ़ चुके हैं, लेकिन ये छोटी छोटी बातें उनको पता ही नहीं होगा. ओके, अनलेस एंड अनटिल एक एमसीक्यू के फॉर्मेट में आता है तो. नेक्स्ट. So this is the historical evolution or the chronological evolution of Article 38. Same thing is mentioned. These are things. Clause 1 was added here, and clause 2 was added. So no need to remember. But this is the whole. This is the whole Article 38. Now coming to Article 39. Certain principles of policy to be followed by the state. There are certain principles of policy which has to be followed by the state or by the government. The state shall. Okay. So here shall. In particular, so this is a kind of a mandatory or a compulsory thing, because wherever shall is used, it is mandatory or compulsory, will direct its policy. It means whatever policy is made by the government, okay, whatever policy, it should be directed towards, or it should be like the objective of that policy should be to secure these things. This is the meaning. Now, what are the things? You have to remember each and everything. That securing that any policy which comes, the government should make sure that the citizens, men and women equally, have the right to an adequate means of livelihood. That the ownership and control of the material resources of the community are so distributed as best to serve up the common good. जो भी आप रिसोर्सेस आप डिस्ट्रीब्यूट कर रहे हो कोई भी कम्युनिटी में, इट शुड सर्व द कॉमन गुड. एग्लिटेरियन सोसाइटी जिसको हम बोलते हैं. इट शुड secure that the operation of the economic system does not result in the concentration of wealth and means of production to the common detriment. मतलब एक पर्टिकुलर चीज के ऊपर, एक पर्टिकुलर लोग के ऊपर concentration of wealth should not be there. Any operation, any economic system, any production you are doing, it should be equally distributed or evenly distributed. Not even equally, but evenly distributed. Okay. Equal pay for equal work for both, for equal work. Okay, for equal work for both men and women. Okay. Now you may think कि कहाँ पे मिलता है equal work? If it is not paid equal, it means the work is also not equal. Work should be equal. Okay. Like for example, there is a payment problem in a lot of industries, like suppose movie industry. There is a most of the people, lot of actors come and say कि there is a payment or pay parity is not there. Okay, but that is actually wrong. Work is not equal. Work is not at all equal. Male stars, they draw huge crowds. Female stars, they draw but not at the not comparable to male stars. So it means the work is not equal because a lot of money is being invested in a particular project. So you have to draw that crowd. So whoever draws more, so the payment will be more. As simple as that. So you can't tell कि equal work है, equal work नहीं है उस time पे. Okay. But if you see in corporate jobs, things are very good. In a Infosys or a TCS or IBM, there is, for equal work you get, the salary will be same because the work is equal. All depends on this. This is the word. Okay. Next. That the health and strength of workers, men and women, and the tender age of children are not abused, and that citizens are not forced by economic necessity to enter vocations unsuited to their age और स्ट्रेंथ. मतलब हेल्थ और स्ट्रेंथ ऑफ सबका, चिल्ड्रन का, वर्कर का, मेन एंड वुमेन का, ऐसे आप पॉलिसी जो ला रहे हो, एनी पॉलिसी यू ब्रिंग, दिस थिंग शुड बी केप्ट इन माइंड. इट इज नॉट अफेक्टेड. ओके. नाउ clause F was added later, okay, in the 42nd amendment. that the children are given opportunities and facilities to develop in a healthy manner and in conditions of freedom and dignity, and that the children and that the childhood and youth are protected against exploitation and against moral and material abandonment. This was added later. Okay, you just need to remember these sentences. That's it. So आर्टिकल 39 का एक्सप्लेनेशन यहाँ पे है, कुछ जुडिशियल इंटरप्रिटेशंस भी हुआ है. In 2013, in some Gujarat case, the Supreme Court stated that the expression common good means common good of a whole state. Fine, it is understood. Now equal pay for equal work. Okay, for equal pay for equal work also some judicial interpretations were there. Okay, here the Supreme Court had observed that denial of equal pay for equal work becomes irrational classification within Article 14. Equal pay for equal work becomes irrational classification. In Article 14 there is a classification, right? We have already studied, but this is it's an old case by the way, but Supreme Court said it is an irrational classification within Article 14. Now some recent case 2016 का case है. Supreme Court stated that in a welfare state an employee engaged in the same work cannot be paid less than another. Fine. Who performs the same duties and responsibilities. Fine. Further, Supreme Court clarified principle of equal pay for equal work and stated that in determining equality of functions and responsibilities under the principle of equal pay for equal work, it is necessary to keep in mind that the duties of two parts should be equal sensitivity and also qualitatively similar. That's what I'm saying. The work should be very much equal in nature. Qualitatively it will be similar, equal sensitivity, the two parts should be exactly equal. Then only this equal pay for equal work concept will come. Okay, even Supreme Court also has validated that thing. Okay, now something regarding child labor. Provisions of Article 39E, 39F, 41 and 47 can be pressed into service to make suitable provisions regarding child labor. Okay. In some MC Mehta case 1997, Supreme Court had issued directions to the state to see that an adult member of the family whose child is in employment in a factory, mine or hazardous employment gets employment anywhere in the lieu of the child. Okay, fine, it is understood. Nothing unique point. Now coming to Article 39A. This was also added later. In 39A, what happened? Equal justice and free legal aid. So this was added in the 42nd amendment. 39A was added in the 40, just remember 39A, equal justice and free legal aid, it was added in 42nd, 1976. So here the state shall secure that the operation of the legal system promotes justice. The state should ensure the legal system, the operation of the legal system, it promotes justice on the basis of equal opportunity, and shall in particular provide free legal aid by suitable legislation, by a law or schemes or any other way. ठीक है, it's not mandatory कि by law only, it can be done by scheme also, not by law भी चलेगा. It can, because or is there here, or is there. Okay, or to ensure that opportunities for securing justice are not denied to any citizen by reason of economic or disability. Give me a recent example. बहुत सारी स्कीम्स है, प्रो बोनो स्कीम करके एक है, तो लीगल एड फ्री में मिलता है. ओके, लेजिस्लेशन है, दैट इज द नालसा एक्ट 1987. It is mentioned here, Nalsa Act of 1987. So this act was established to have a nationwide uniform network for providing free and competent legal services to the weaker sections of the society. They don't have money, right? So free legal services will be given to them. Every person who has to file or defend a case shall be entitled to legal services under this act if the person has an annual income of not more than 1 lakh. So in this act, the government said any person who does not have more than 1 lakh, okay, then he can file. Legal services will be given to them. In the Supreme Court, the limit is 1,25,000. No need to go in detail of this act, but at least you should know it has to give effect to Article 39A. Nalsa Act was enacted. Okay. But this limitation is not applicable to scheduled caste, scheduled tribes, women and children, industrial workers, prisoners in jail, victims of communal violence, natural disaster, mentally disabled. Not. What you can do is Nalsa Act आप अलग से पढ़ सकते हो. You never know, question can come. Nalsa Act का कुछ important things जो provisions है आप अलग से पढ़ सकते हो. करंट अफेयर में काफ़ी न्यूज़ में रहता है. आई विल बी कवरिंग इन करंट अफेयर्स, बट जो सेल्फ स्टडी के लिए आप अलग से कर सकते हो. फिर 1991 में सुप्रीम कोर्ट हैज हेल्ड दैट लीगल एड मे बी ट्रीटेड एज अ पार्ट ऑफ आर्टिकल 21. अगेन this can come as a question. Legal aid may be treated as a part of Article 21, right to life. Okay. Now coming to Article 40. Article 40 भी काफी important है. Article 40 is organization of village panchayats. तो ये गांधी जी का गांधीयन प्रिंसिपल है, एंड दिस वाज वन ऑफ द ड्रीम ऑफ महात्मा गांधी. तो द स्टेट शैल टेक स्टेप्स. ओके, बट ये होते होते काफ़ी लेट हो गया. द स्टेट शैल टेक स्टेप्स टू ऑर्गेनाइज विलेज पंचायत्स. पंचायती सिस्टम बहुत बाद में आया, 90s में, 1993 पे आया. एंड endow them with such powers and authority as may be necessary to enable them to function as units of self. So it promotes self-government at local level. Okay. It was a Gandhian ideology where Gandhiji wanted democracy at grassroots level and decentralization of power at the lowest level. So to the जो पंचायती राज जो चैप्टर हम पढ़ेंगे आगे, तो the पंचायती राज was a outcome of this article, Article 40. Article 41. Okay, Article 41 is right to work, to education, and to public assistance. In certain cases, the state shall, within the limit of its economic capacity, like there is a limit, like the state economic capacity होना चाहिए, मतलब उनके पास the government should have that capacity economically. Within the limits of economic capacity and development, make effective provision for securing the right to work. Example, the मनरेगा, ठीक है, मनरेगा एक्ट 2005. राइट टू वर्क, टू एजुकेशन, राइट टू एजुकेशन भी हमारे पास है 2009. ठीक है. एंड टू पब्लिक असिस्टेंस इन केसेस ऑफ एम्प्लॉयमेंट, ओल्ड एज, सिकनेस, डिसेबलमेंट एंड इन अदर केसेस ऑफ अनडिजर्व्ड वार्म के लिए द स्टेट कैन मेक रूल्स और लॉज और एनी काइंड ऑफ प्रोविजंस. फॉर व्हाट? नंबर 1, you have to remember like this: right to work, right to education, ठीक है, then public assistance in cases of unemployment, old age, sickness, disable, and in other cases. But these are the disablement, sickness, old age, unemployment पे public assistance मिलेगा, right to work, right to education. But All these things are conditions ki limits of, within the limits of economic capacity and development. Okay, तो ऐसा करके आप इसको याद करोगे. मतलब ऐसा नहीं कि at any time it has to do it, no, limits है, but nothing is absolute. Again and again I'm telling, nothing is absolute here. Fine. So in 2013 a case हुआ था. Supreme Court had stated that it is the duty of the state to make effective provisions for securing inter alia the rights of the disabled and those suffering from other infirmities within the limits of economic capacity and development of the state under 41. So Supreme Court also has validated this key, yes, it can do, but within the limits of economic capacity. Coming to Article 42, provision for just and human conditions of work and maternity relief. ठीक है, maternity relief के लिए we have an act, Maternity Benefit Act of 1961. Recently it was amended in 2018. Okay, so this act has been done Article 42 को enforce करने के लिए. Maternity relief के बारे में now no need to go to original act, you can go for the amendment one, जो amendment हुआ है 2018 में. It is a part of our current affairs. जो changes हुए हैं 12 to 26 weeks, वो सब चीज 2 to 3 provisions you have to remember. It is available everywhere. Okay. In 2001 case happened, very old case, no need to go through. Okay, 43 का क्वेश्चन 2017 में आया था. दिस वाज द क्वेश्चन व्हिच केम 43A, डायरेक्ट क्वेश्चन आया था 2018 में आया था. यस, लिविंग वेज एक्सेट्रा फॉर वर्कर्स, द स्टेट शैल एंडेवर टू सिक्योर बाय अ सुटेबल लेजिस्लेशन और इकोनॉमिक ऑर्गेनाइजेशन. ध्यान से, द स्टेट शैल एंडेवर टू सिक्योर बाय ए लॉ, और ठीक है, ये हो गया लॉ, और इकोनॉमिक ऑर्गेनाइजेशन से भी कर सकते हैं. एनी काइंड ऑफ ऑर्गेनाइजेशन, इकोनॉमिकली कुछ ऑर्गेनाइजेशन जोड़ के द स्टेट शैल एंडेवर फॉर अ लिविंग वेज फॉर वर्कर्स और इन एनी अदर वे. ठीक है, टू ऑल वर्कर्स, एग्रीकल्चरल, इंडस्ट्रियल or otherwise, work a living wage, conditions of work ensuring a decent standard of life and full enjoyment of leisure and social and cultural opportunities, and in particular the state shall endeavor to promote cottage industries on an individual or cooperative basis in rural areas. So एक एक वर्ड बाय वर्ड जाओगे. 43 आर्टिकल क्या बोलता है, स्टेट क्या करेगा. तो स्टेट विल फर्स्ट ऑफ ऑल लिविंग वेज फॉर वर्कर्स. हाउ, कैसे स्टेट कैसे करेगा. वन इज थ्रू लॉ, थ्रू एन इकोनॉमिक ऑर्गेनाइजेशन, और एनी अदर वे, डिपेंड स्टेट को सही लगेगा तो. टू ऑल वर्कर्स क्या करेगा, टू ऑल वर्कर्स, खास करके लिखा क्या है, टू ऑल वर्कर्स ऑफ एग्रीकल्चरल, इंडस्ट्रियल. ठीक है, ताकि they get social and cultural opportunities, they enjoyment, full enjoyment of leisure. ठीक है, and in particular state को promote करेगा cottage industries on an individual और cooperative basis. ठीक है, ओके. सो आपको ऐसे ही याद करना है, इंडिविजुअल और कोऑपरेटिव बेसिस में भी. Now 43A was added later. 43A was added in the 42nd amendment. 42nd amendment 1976 में A was added, that is participation of workers in management of industries. तो यहाँ पे इन पर्टिकुलर इंडस्ट्रीज वर्कर का जो काम करते हैं इंडस्ट्रीज में उनके लिए एक सेपरेट आर्टिकल ऐड किया गया। तो यहाँ पे लिखा क्या है, द स्टेट शैल टेक स्टेप्स बाय सुटेबल लेजिस्लेशन or in any other way to secure the participation of workers in the management of undertakings, establishments or other organization engaged in any industry. ठीक है, by law or in any other way. यहाँ पे economic organization is not mentioned. Okay, this is old case, not required. Now 43B, promotion of cooperative activities, cooperative societies. ठीक है, now this was added in the 97th Amendment Act. Okay, this was added in the 97th Amendment Act of 2011. Cooperatives was added. Okay, so this total clause 43B, 97th. The state shall endeavor to promote voluntary formation, autonomous functioning, democratic control and professional management of cooperative societies. ठीक है, हम पढ़ते क्या है 43B cooperative societies ऐसे पढ़ते हैं, नो गलत हो जाएगा. If they want to make it more tricky because they exactly know how we study the book. ठीक है, चार चीज, the state shall endeavor, स्टेट हमेशा प्रमोट करेगा क्या, वॉलंटरी फॉर्मेशन ऑफ, आप वॉलंटरली फॉर्म कर सकते हो कोऑपरेटिव सोसाइटी, उनका ऑटोनोमस फंक्शनिंग, उनका डेमोक्रेटिक कंट्रोल, उनका प्रोफेशनल मैनेजमेंट को प्रमोट करेगा द गवर्नमेंट. ओके, नेक्स्ट, यूनिफॉर्म सिविल कोड. यूनिफॉर्म सिविल कोड फॉर द सिटीजन्स. Now uniform civil code is a debatable topic. Like some section of the people say it is required, some section of the people say it is not required. So it's a potential mains question. Okay, so here simply it has been mentioned that the state shall endeavor to secure for the citizens a uniform civil code throughout the territory of India. Okay, now uniform civil code of the constitution, that is article 44, requires the state to secure for the citizens of India a uniform civil code throughout the territory of India. India is a unique blend and merger of codified personal laws. हिंदूज का पर्सनल लॉज है, मुस्लिम्स का है, क्रिश्चियंस का है, पारसीस का है, अलग अलग पर्सनल लॉज है. However, there exists no uniform family law. सबका अलग अलग लॉज है. There is no uniform family law in a single statutory book for all Indians, which is acceptable to all religious communities coexisting in India. It is not there. The question is not of minority protection or even of national unity. It is simply one of treating each human being with the dignity that he deserves, something which the personal laws have so far failed to do so. It is not about minority protection or something. See, it is about, see, the thing is, on one side we are saying secular, equal treatment to all religions. Is this equal treatment to all religion? Different personal laws of this. It's not right. On one side you are saying you are supporting secularism, on one side you are not supporting UCC. That is what that is the issue which is happening now. You have to support either one or you have to go via constitution. Secular matlab equal treatment of all religions, and when UCC is not there, it means we are not promoting secularism, where all religions have different, how then the country, the government is not equally treating them. So to preserve this secular aspect, we have to bring UCC. Yes, it is difficult to bring, but I'm only talking about this particular thing, secular and UCC. I'm not talking about whether it will be accepted or not. I'm not going there. I'm simply telling whatever the constitution says. Okay, fine. So it is based on the concept that there is no necessary connection between religion and personal law in a civilized society. Article 25 guarantees religious freedom, whereas Article 44 seeks to divest religion from social relations and personal laws. It is saying personal laws को religion को अलग करो. Yes, religious freedom is there. Religious freedom is there. Everyone can profess their own religion. But when it comes to personal laws, उसको religion से अलग करो, because कहीं ना कहीं social relations get affected, right? Marriage, succession, and like matters of a secular character cannot be brought within the guarantee enshrined under Article 25, 26, and 27. ये जो चीज़ है, मैरिज, सक्सेशन, ये सब अलग अलग धर्म का अलग अलग रूल्स होता है, राइट? सो दे कैनॉट बी ब्रॉट अंडर आर्टिकल 25, 26 एंड 27, जो हमने ऑलरेडी पढ़ रखा है, बिकॉज कहीं ना कहीं ये सब पर्सनल लॉज में आ जाते हैं. गोवा इज अ साइनिंग एग्जाम्पल ऑफ एन इंडियन स्टेट विच हैज अ यूनिफॉर्म सिविल कोड applicable to all, regardless of religion, except while protecting certain limited rights. But overall, Goa is the only state in India which has uniform civil code, अपना खुद का है. Now the thing is, when you write a answer, UCC का answer, which I have already done in mains, see, Supreme Court in various judgments, see, no, you are not bigger than Supreme Court, right? So Supreme Court का जजमेंट आप हमेशा लिखोगे आंसर में. अपना आइडियोलॉजी को थोड़ा पीछे रखकर यू हैव टू गिव द जजमेंट्स, यू हैव टू गिव कॉन्स्टिट्यूशनल प्रोविजंस एंड यू हैव टू गिव सुप्रीम कोर्ट प्रोविजंस. दैट्स इट. सुप्रीम कोर्ट ने सपोर्ट किया है इन वेरियस जजमेंट्स. For example, in 1985, it said Article 44 of the Constitution has remained a dead letter. There is no evidence of any official activity for framing a common civil code for the country. It means it has remained a dead letter. Then why to keep? It is there, so do it. In 1985, the Supreme Court said a common civil code will help the cause of national integration. Now, recently one UPSC, one Odisha PCS में question आया था, okay, this year only, prelims में, last year or this year, exactly don't remember. It was a very tricky question. It was a very tricky question कि uniform civil code, which of the following gets preserved by uniform civil code, or what does it refer to? So 4 points were there, very near to near points. One point was this national integration. Okay. Somewhere it was mentioned about religions, something was mentioned, like it was very neck to neck answer, okay, like very thin line difference was there between the options. So the answer is national integration. So for that you need to have that conceptual clarity, okay, to answer those kind of questions. So a common civil code will help the cause of national integration by removing disparate loyalties to laws which have conflicting ideologies. It is the state which in charge with the duty of securing a uniform civil code for the citizens, for the country, and unquestionably it is the legislative competence to do so. The government should do so, it is saying, okay, because obviously it will help in national integration, right? Because everywhere everybody will have a common civil laws. Criminal laws are the same for everyone, right? Criminal laws are the same, but civil laws will also be the same. Then it will, in a way, it will bring everyone together. Equality, national integration. Again, in Supreme Court in 1995, Sardar Mudgal case requested the government of India through the Prime Minister of the country to have a look at Article 44 of the Constitution of India and endeavor to secure for the citizens a uniform civil code throughout the territory of India. Again, in Jol Valamottam case 2003, Supreme Court said it is a matter of regret that Article 44 of the Constitution has not been given effect to. It's a regret it has not been given effect. Parliament is still to step in for framing a common civil code in the country. A common civil code will help the cause of national integration by removing the contradictions based on ideologies. Okay? But yes, it will be difficult. It is debatable in today's time because everybody has their own laws. In a way, बहुत सालों से चलता आ रहा है, कहीं ना कहीं प्रथा बन चुका है. तो suddenly change करने में it will take time, but in that sense it may create problems also. Communal disharmony हो सकता है, but consultation करके the government should consult people, consult the leaders of different religions and then come. Suddenly आने से बेहतर है कि you discuss, debate and then bring. Okay.
Excuse me, sir.
Yes.
सर कोई एग्जांपल गोवा के किसी ऐसे लॉ का जिससे कि मतलब कि एप्लीकेबल होता हो ये यूनिफॉर्म सिविल कोड, किस तरह से? मतलब
कोई लॉ, मतलब गोवा में लॉज है सबके लिए, सेम सिविल लॉज है.
ओके
गोवा में जो गोवा के जो लोग हैं उनके लिए सिविल लॉस सबके लिए सेम इरेस्पेक्टिव ऑफ रिलीजन.
ओके सर
ठीक है.
ओके
Okay. Now, Article 45. Article 45, provision of early childhood care and education to children below the age of 6 years. Okay, ये भी है. Below the age of 6 years, there should be a provision for early childhood care. तो दो चीज़ है. क्या है? Early childhood care and education to children below 6 years. Article 45. ठीक है. Okay, so the state shall endeavor to provide early childhood care and education for all children until they complete the age of 6 years. Directive. Article 46, promotion of educational and economic interest of scheduled caste, scheduled tribe and other weaker sections. तो द स्टेट शैल प्रमोट इट स्पेशल केयर, उनके लिए एक स्पेशल केयर दिया जाता है. कहाँ पे? एजुकेशन में, इकोनॉमिक इंटरेस्ट में. ओके. और द वीकर सेक्शन ऑफ द पीपल, इन पर्टिकुलर द शेड्यूल्ड कास्ट एंड शेड्यूल्ड ट्राइब्स, एंड शैल प्रोटेक्ट देम फ्रॉम सोशल इनजस्टिस and all forms of exploitation. It is the duty of the government. Article 46. Remember the article names. So weaker sections में हमने पढ़ा भी है. इंदिरा सोनी केस हमने फंडामेंटल राइट्स में ऑलरेडी वी हैव कवर्ड इट. सो यहाँ पे कुछ ज़्यादा कुछ है नहीं. कमिंग टू आर्टिकल 47. 47 में कीवर्ड्स क्या है? ड्यूटी ऑफ द स्टेट टू रेज द लेवल ऑफ न्यूट्रिशन. ठीक है. बहुत सारे स्कीम्स हैं. पोषण अभियान, नेशनल फूड सिक्योरिटी एक्ट. ठीक है. एंड स्टैंडर्ड ऑफ लिविंग एंड टू इम्प्रूव पब्लिक हेल्थ. पब्लिक हेल्थ के लिए तो हेल्थ के लिए नेशनल हेल्थ मिशन, बहुत सारी चीज़ें हैं. हेल्थ कनेक्टेड बहुत सारी चीज़ें हैं. आप अलग अलग डायमेंशन से लिख सकते हो. द स्टेट शैल रिगार्ड द रेजिंग ऑफ द लेवल ऑफ द न्यूट्रिशन एंड स्टैंडर्ड ऑफ लिविंग ऑफ इट्स पीपल. ठीक है. And the improvement of public health as among its primary duties, and in particular the state shall endeavor to bring about prohibition of the consumption except for medicinal purposes for intoxicating drinks and of drugs which are injurious to health. तो ये भी एक स्टेट का है जो कि स्टेट नहीं कर रही है. ओके. तो ये सब गांधीयन, ये भी गांधीयन पॉइंट है जो कि गांधी जी चाहते थे, बट सैडली इट्स नॉट डन. कुछ कुछ जैसे कि फॉर एग्जांपल बिहार, गुजरात और कौन सा स्टेट है, केरला भी है आई गेस टू सम एक्सटेंट, बट गुजरात एंड बिहार तो है, तो उन्होंने किया है. तो कुछ कुछ स्टेट्स कर रहे हैं लेकिन ओवरऑल नहीं हो पा रहा है. ओके. प्रोहिबिशन ऑन लिकर बिजनेस में 2013 में सुप्रीम कोर्ट ने बोला था, सुप्रीम कोर्ट हैज हेल्ड दैट ए सिटीजन हैज नो फंडामेंटल राइट टू ट्रेड और बिजनेस इन लिकर. ये फंडामेंटल राइट कहीं पे नहीं लिखा है. हमने इतना फंडामेंटल राइट पढ़ा, हुई कवर्ड ईच एंड एवरी एस्पेक्ट ऑफ ऑल द फंडामेंटल राइट्स, बट nowhere it's mentioned कि they have fundamental right. Even in Supreme Court judgments also, the state can prohibit completely trade or business in portable liquor. State can do. Some states have already done. Or the state can also create monopoly in itself for the trade or business in such liquor. Most of the states has state governments. Most of the state governments has monopoly in this particular business. Recently Delhi government privatized it. Recently, like last month only. Okay. Okay. Now 48. So it means you could see, if you see 47, the DPSP and see the Supreme Court judgment. So there is a difference, because here see, the state shall endeavor, will try their best to prohibit. Okay. But in Supreme Court judgment, the state can prohibit and the state can create monopoly also. So two like polarizing statements, right? Two extreme sentence. Fine. But see, the state can create monopoly. It is a Supreme Court judgment. It is not mentioned in the Constitution. Constitution में it is mentioned that the state shall take all possible steps to bring prohibition of the consumption except medicinal purpose. ठीक है? Organization of Agriculture and Animal Husbandry, Article 48, very famous. The state shall endeavor to organize agriculture and animal husbandry on modern and scientific lines, and shall in particular take steps for preserving and improving the breeds and prohibiting the slaughter of cows and calves and other milch and draught cattle. ठीक है, तो यहाँ पे भी स्टेट कर सकती है, स्लॉटर ऑफ काउज पे प्रोहिबिट कर सकती है. इट इज मेंशन्ड इन DPSP. Okay, some states are also doing it. 48A. 48A, protection and improvement of environment and safeguarding of forest and wildlife. The state shall do it, protect and improve environment, forest. बहुत सारे schemes हमें environment में, we have already studied in environment की. Environment के लिए government is doing lot of things, lot of schemes and all. Laws भी हैं environment, wildlife को बचाने के लिए, there are laws in place. Okay. Recently in Arjun Gopal case, 2017, the Supreme Court held that the use of fireworks in NCR is a major source of noise and air pollution, causing immense harm to lives and health of citizens. It is the duty not only of the state but also of citizens to ensure healthy environment, जो कि दिल्ली में बिल्कुल नहीं हो पाता है दिवाली के टाइम पे. So it is not state का तो responsibility, even citizens का भी responsibility है कि healthy environment को maintain करने का एक duty होना चाहिए. 49. Protection of monuments and places and objects of national importance. So this is the keyword here, national importance. It shall be the obligation of the state to protect every monument or place or object of artistic or historical interest. ठीक है? Declared by or under law. This clause, this statement was added in the 7th Amendment Act 1956. It was not originally mentioned that this is this part. Anything which is declared by law, see, anything of national importance has to be declared by law. Okay, so those the protection of those monuments of national importance, it shall be the obligation of the state to protect it. Okay, from spoliation, disfigurement, destruction, removal, disposal, or export, as the case may be. Okay, and we have laws in place, Antiquities Act and all, lot of laws we have in current affairs we have studied. Now 50, separation of judiciary from executive. The state shall take steps to separate the judiciary from the executive in public services of the state. Promotion of international peace and security. ठीक है, अभी this is now relevant now in today's time. यूक्रेन और रशिया का जब वॉर चल रहा है, so एक इंटरनेशनल पीस के लिए भी जरूरी है. So the states shall endeavor to promote international peace and security, maintain just and honorable relations between nations, foster respect for international law and treaty obligations in the dealings of organized peoples with one another. There are a lot of international law where India has signed and ratified. So it's an endeavor to foster respect for that international law also, and encourage settlement of international disputes by arbitration. Arbitration मेथड से ही आप सेटलमेंट करोगे इंटरनेशनल डिस्प्यूट्स को. जो प्रॉब्लम होता है आर्बिट्रेशन से, आप कहीं पे भी ICJ जाओ या फिर परमानेंट कोर्ट जाओ, लॉट ऑफ आर्बिट्रेशन इंटरनेशनल ऑर्गेनाइजेशंस आर देयर. ओके, वर्ल्ड बैंक में भी है आर्बिट्रेशन, ठीक है, हर जगह है. सो ये आर्टिकल 51 बोलता है. नाउ फंडामेंटल ड्यूटीज 4A was added later. ओके, 1976 में ऐड हुआ, सोरेन सिंह कमेटी का रिकमेंडेशन से. सो हियर इट इज अ ड्यूटी. सो दिस ड्यूटीज आर लोगों का ड्यूटीज है, सिटीजन्स. इट इज द ड्यूटी ऑफ एवरी सिटीजन ऑफ इंडिया टू अबाइड बाय द कॉन्स्टिट्यूशन एंड रेस्पेक्ट इट्स आइडियल्स एंड इंस्टीट्यूशंस, नेशनल फ्लैग, नेशनल एंथम. ठीक है, कीवर्ड बोल देता हूँ, उस हिसाब से याद करोगे. अबाइड बाय कॉन्स्टिट्यूशन, उसका आइडियल और मतलब ये कॉन्स्टिट्यूशन, दिस इज द कीवर्ड, नेशनल फ्लैग, नेशनल एंथम. To follow the noble ideals which inspired our national struggle for freedom. तो चेरिश एंड फॉलो जो हमारा नेशनल स्ट्रगल फॉर फ्रीडम है, खास करके दिस इज नथिंग बट मॉडर्न हिस्ट्री. ओके, जो मॉडर्न हिस्ट्री में वी हैव स्टडीड अ लॉट ऑफ थिंग्स एंड विल बी स्टार्टिंग दिस अगेन like before prelims. So lots and lot of things you have already covered, so it is your duty to cherish and follow so that prelims और mains में भी काम आ जाएगा. जरूरी है. contributions and all, रविंद्रनाथ टैगोर से लेके लाला लाजपत राय तक, तिलक से लेके स्वामी विवेकानंद तक, गांधी जी तक, अंबेडकर तक, everything you have to, which inspired our national struggle for freedom. To uphold and protect the sovereignty, unity and integrity of India, to defend the country and render national service जब भी जरूरत पड़े, when called upon to do so. To promote harmony and spirit of common brotherhood among all the people of India, transcending religion, linguistic and regional or sectional diversities, to renounce practices derogatory to the dignity of women. This is the thing which is needed now. Whenever you write a mains answer, we all write a lot of things we write. We can add one point. It is our fundamental duty to promote this, which you are not doing. Irrespective of religion, language, region, any kind of diversity, we have to promote the spirit of common brotherhood. To value and preserve the rich heritage of our composite culture. To protect natural environment को protect करो, जैसे कि forest, lakes, rivers and wildlife. And to have compassion for living creatures. To develop the scientific temper, humanism and the spirit of inquiry and reform. ओके, ह्यूमनिज्म, साइंटिफिक टेम्पर, मतलब जो भी आप बात कर रहे हो, डू इट इन अ वेरी ह्यूमनिस्टिक वे, लॉजिकल, रैशनल. ठीक है. टू सेफगार्ड पब्लिक प्रॉपर्टी एंड टू एब्ज्योर वायलेंस. पब्लिक प्रॉपर्टी ये भी नहीं हो पाता है आजकल. व्हेन यू डू स्ट्राइक एंड ऑल, पब्लिक प्रॉपर्टी को हम डैमेज करते हैं. वी डैमेज पब्लिक प्रॉपर्टीज, राइट. स्ट्राइक्स एंड ऑल रिसेंट केसेस में बहुत सारे हुआ है. To strive towards excellence in all spheres of individual and collective activity, so that the nation constantly rises to higher levels of endeavor and achievement. This one was added later in the 86th amendment. The last one was added in the 86th amendment. This one, 86th amendment 2002. Who is a parent or guardian to provide opportunities for education to his child, or as the case may be, what between the age of 16 and 14. एजुकेशन के लिए. ओके. So part 4 issues guidelines to the citizens to do or not to do certain things in the interest of their country, fellow citizens and also for themselves. Fundamental duties did not form part of the constitution as originally adopted. It was not there, but in 1976 by the 42nd Amendment Act and the recommendation of the Solan Singh Committee, it was added. Okay. And in 86th Amendment 2002, one more fundamental right was added, that is every parent. This was for every parent, not for all, for every parent, the last one, or guardian has a duty to provide educational opportunities to his child or ward between the age of 16 and 14. But the thing is, fundamental duties are not like enforceable in courts directly. Okay, so these are not enforceable. They cannot be enforceable by writs. They can only be promoted. They can be promoted only by constitutional methods. They can be used, but yes, they can be used for interpreting ambitious state laws. Like if the laws, if there is a law which is not that much clear, or the clarity, there is a demand for any clarity or interpretation. The Supreme Court or the judiciary can use it, can use the fundamental rights and DPSPs to interpret the validity of laws or constitutionality of laws, can be used to interpret the validity of laws, but they cannot directly be enforced. Okay. Okay, fundamental, in one more case, this was 1976 case. In one more case, fundamental duty is a valuable guide. It is a valuable guide. 2002 एम्स का केस हुआ था. The Supreme Court observed that fundamental duties are not enforceable by courts, yet they provide a valuable guide. ठीक है, and aid to interpretation. That's what I said now. कि yes, constitution मतलब interpret करने के लिए they can be used as a guide. The Supreme Court further held that the duties must be used as a tool to control state action drifting from constitutional values. If any state is doing something like it's not adhering to the constitutional values, then the duties must be used as a tool to control that state action, to control that action of the government. If it is drifting or moving away from constitutional values, fundamental duties can be used as a tool. We can use as a tool, or even the Supreme Court said it must be used as a tool. When a state is drifting away from constitutional values, this statement can come in prelims. It can come, they may ask if the fundamental duties cannot be used as a tool to control state action drifting from constitutional values. You will feel yes, the answer is correct. Fundamental duties cannot be used. It is the fundamental rights. You may think fundamental rights, obviously fundamental rights are there. But the Supreme Court also told that it must be used as a tool. Fundamental duties also must be used as a tool to control state action drifting from constitutional values. Remember. Okay. Okay. Now recent news भी था national anthem cinema hall पे. It is not mandatory now. Okay, it is not mandatory. Playing of national anthem in cinema hall not mandatory. In case of this Narayan Choksi case, 2018 Supreme Court held that they held that the playing of national anthem by movie halls shall be deemed to be directory and not mandatory. Nowadays, if you find in some theaters they are playing, in some theaters they are not playing. Mostly in multiplexes they are playing, but in single theaters mostly they are not playing. So it is not mandatory now. There was time when it was mandatory. For some time it was mandatory, but the case went to Supreme Court and Supreme Court said it is not mandatory. But the bench clarified that if the cinema hall chooses to play the anthem, then it shall be compulsory for every person in the audience to stand in respect thereof, unless they are entitled to exemption on account of disability. If they are playing it, you have to stand. There was a debate ki why we need to stand. Some section of the people told you why need to stand, why to show nationality it is not required. Some things were going on social media at that point of time, but it is compulsory for every person to stand unless and until you are disabled. Okay? But playing the song is not mandatory. It's only a directory. It's up to the cinema hall to do. Okay. So we are done. I'll cover one more thing now. So part 4 is done. Part 5 is continued with Union Executive Article 52, which you have already covered in our previous videos. Okay. So you can revise from there also. Now coming some extra points. Okay. So cancel this. So DPSP, some extra points. It is DPSP social and economic justice. Even political justice is also mentioned in Article 37. But mostly political justice is done by fundamental rights. Okay. Now Nehru's idea of now this socialism part, when DPSP comes, so we always think about socialism. So Nehru's idea of socialism is that every individual in the state should have equal opportunity for progress. That was Nehru's ideas of socialism. Every individual should have equal opportunity for progress. Article 36 we covered now. There it is mentioned that the state shall promote with special care the educational and economic interest of the weaker section of the people, and in particular of SC and STs, and hence shall protect them from social injustice and all forms of exploitation. Now classification of DPSP, we have socialistic, we have Gandhi, and we have liberal. All these things have clearly mentioned in Lakshmikant. Okay, so it's mentioned in Lakshmikant, but the constitution does not mention any classification. We read the constitution right now. Okay, however, any article, did it classify? No, classification is done by us. It is there in the book, it is done. For exam point of view, it's not mentioned in the constitution. There is no mention of classification. Simply starts from 36, ends in 51. Okay. Okay, some important points apart from Lakshmikant here. Article 39B, it gives power to the state to direct its policies regarding ownership, control of material resources of the community, and to make policies to help distribute these resources in the best possible way. Already discussed. the power to nationalize. Now see, extra thing is, if you see this, so the state has the power to direct its policy regarding the ownership. Ownership means what? Any company ownership, shareholding. So here, if you see, the power to nationalize is implicit in it, is understood. Power to nationalize a government. Ownership it can do. It can direct any policy regarding ownership. From today, I'll own this 51% or a 60% or a 49%. So if that is necessary to ensure a better distribution of the ownership of material resources to achieve the common good. So this was given by 1978 Supreme Court case, State of Karnataka versus Ranganathan. The power to nationalize is implicit in Article 39B, if that is necessary to ensure a better distribution. If the government thinks, yes, by ownership, it will be better, the distribution of resources will be good, then yes. So it has come from here only, Article 39B. So they can ask you, let's say organization of village panchayat is Article 40. So nationalizing thing is Article 39B. As per Pandit Nehru, socialistic term pattern of society, not socialism, was declared to be the objective of our planning. We needed a socialistic pattern of society, not pure socialism, because we needed a pattern, because we also had, because we are mostly into mixed economy. Okay, we had socialist, we have also capitalist tendency, but during that point of time, initially after independence, it was a socialistic, more of socialistic. So we needed a socialistic pattern of society where equal opportunities will be given for everyone, inequalities will not be there. Okay, PSUs will be working. Obviously, industries like private industries can come, but for them, license will be required. Okay, mere insertion of the word socialist in the preamble does not introduce socialism in its collective sense, because a preamble merely serves as a key to the enacting provisions, but cannot add or modify the law. Preamble is nothing. Preamble is also not enforceable, right? Preamble is like a preface. Preamble is like a preface. Before you read a book, you read the preface, right? What all things will be there in the book, you get an idea. So merely if you add a socialist, it does not mean ki on whole sense our country become a socialist country. If that would have been the case, then there would have been no place for capitalism here. Pure socialism does not support capitalism. Pure capitalism does not support socialism. Remember, I'm talking about pure, the term, the literal meaning of the term. So in India, we had a socialist pattern of society. Merely adding the word socialist in a preamble will not introduce the full-fledged socialism in its collective sense. Okay. Fundamental rights are enforced by courts, obviously at 32, 26 for High Court. Are the courts are bound to declare any law as void that is inconsistent with fundamental? Okay. Article 37 declares that DPSP shall not be enforceable by any court. DPSP shall not be enforceable by any court. The principles laid down are nevertheless fundamental in the governance of the country. Yes, clearly mentioned 37 we discussed now. And it shall be duty of the state to apply these principles in making laws. It is the duty of the state to apply these principles. The courts cannot declare any law as void on the ground that it contravenes any DPSP, unless and until DPSP has been converted into a law. So if the UCC is not there now, you cannot simply go to court and say ki, why we do not have UCC, because it's there in Article 44. We need a law for that. The courts are not competent. Now this is another thing. The courts are not competent to compel the government to carry out the DPSP. I clearly told you that nobody can compel the government that you have to do this DPSP. Just like if Article 44, take the example of Article 44. Nobody can come and compel that you have to do it. No. Even the courts cannot do. Remember, nobody can compel the government. The courts also cannot compel. The court only gave guidelines. Yes, UCC is required or you can do UCC, but it is not compelling the court. The courts are saying from 1990s, UCC has to be there. It is needed for XYZ reasons, but it is not compelling. Till now, the government is not able to do. In case of any conflict between fundamental rights, that is part 3 and part 4, part 3 shall prevail in the courts. In the courts, part 3 shall prevail. State of Madras and Champakam case में बोला था कि the part 3 shall prevail in the courts. Okay. Obviously part 3 shall prevail because it is more, it is strong, and it talks about rights, it is enforceable directly. But yes, in another doctrine, the doctrine of harmonious construction, the court said that both should complement each other, they should not fight with each other. Both fundamental rights and DPSP should complement each other. Now one thing for exam point of view, whether article 355 and 365 can be applied to enforce implementation of DPSP. It means if a state enforce implement is not following any kind of DPSP, can precedent's rule can be imposed? Now it is a prelims question. Now what article 355 and 365 are related to article 356, right? So 355 says that it shall be duty of the union or the center to ensure that the government of every state is carried on in accordance with the provisions of the constitution. Clear cut article 355 says, when you study about emergency we'll come to know, but it is a very common thing. It is a duty of the union to ensure that the government of every state is carried on accordance with the provisions of the constitution. Obviously DPSP is also a part of constitution, right? ठीक है, article 355 says. Now article 365, okay, 365 says if it is not doing, if you are not able to do this, you are not following, if the state has failed to comply, state means state government, if the state government has failed to comply, then or comply with any directions given by the union in its executive power, it shall be lawful for the president to hold that a situation has arisen in which the government of state cannot be carried on in accordance with the provisions of the constitution, and they can put article 356 precedence rule they can put. ठीक है, so precedent rule आता कहां से है? From article 365 it comes. ठीक है, 355 में directions दिया जाएगा, the union gives directions in its executive power. Now where if it is failing to do it, then the president may hold a situation ki okay, now the government of state cannot be carried out. Hence it should be competent, for example, hence it should be competent for the union to issue directions against particular states to introduce, to ensure free or compulsory education for children. This is a DPSP. Okay, the union can issue directions, or to prevent slaughter of cows and other milks, article 48 DPSP, and so on, anything. Now in case refusal by states, it means the state is refusing, okay, it means article 365, then the union may apply article 356. May. Obviously there are conditions before applying 356. Lot of conditions are there, like Supreme Court has told to go for SR Bommai case guidelines 1993 में जो guidelines दिया गया था, but it is a condition, it can be done. ठीक है, now in prelims they will just like in tricky बनाने के लिए what they can do, they will tell in one sentence कि DPSPs are not justiciable, right? They are not justiciable by the courts. So they will add that statement and say that's why in assertion or reasoning question, that's why the union cannot apply precedence rule. You may think it is correct, but it is wrong. They may apply. Because if this is not the case, otherwise directives in part 4 shall ever remain a dead letter. There is no need. Though the courts cannot declare a law to be invalid on the ground that it contravenes a DPSP, obviously, but courts cannot declare a law to be invalid on the ground that it contravenes a DPSP. If there is any law and it contravenes DPSP, so there the court cannot say it is void. But if there is a law and it contravenes fundamental rights, then the court has the court can tell it like give verdict as void. But here they can't. But
Sir,
yes.
But like if central enforcers telling to the state telling that according to DPSP, if they are not following, president means like central can take over it, right?
Yes, may if the condition is right. Okay. So this case is done. 356 case is done. This is already we have covered. Though the courts cannot declare a law to be invalid on the ground that it contravenes a DPSP. Nevertheless, the constitutional validity of many laws have been maintained with reference to DPSP. Like I told you, DPSP and fundamental duties can be used to check the validity and constitutionality of laws, so that they do not serve as mere moral anomaly. सिर्फ moral के लिए नहीं है, they have some rules. So if a mains question come कि importance of DPSP, ये सब points आप लिख सकते हो, they will fetch you very good marks. Plus obviously the court said doctrine of harmonious construction, Supreme Court, both should complement each other. Okay, and there are other directives also in other parts like 350A. When we reach there, we'll cover 350A insertion in mother tongue as primary stage, 351 promotion of Hindi language, and 335 related to SC and STs. We'll be covering it when we reach there. So we're done with fundamental rights and DPSPs. Now you can cover the MCQs. I have already shared how to cover. You can cover the MCQs and go through Lakshmikant book and this video, so that you'll get that holistic coverage. Okay, fine then. Thank you.